estate tax issues, a basic estate plan with estate taxes in mind. And we're also going to discuss retirement accounts, predominantly IRAs, and how those work into your estate plan, because they have become an incredibly important part of a lot of people's estate plans, and the rules about them are different than the rest of estate planning. So definitely something to be aware of. Disclaimer here, takeaway is really your estate plan is very much a team effort. And so it's important to have your attorney, your CPA, your financial advisor all talking so that your overall financial picture and your estate plan work together. There are certain areas where if those three individuals aren't speaking, then each of them can be doing what they think is in your best interests and can be undoing or making the other parts of it more complex. So definitely get those folks talking to each other. My background, I'm a Washingtonian by choice. I'm a Tennessee native. You'll probably hear the drawl in my voice from time to time. Went to Vandy undergraduate, University of North Carolina for law school, and then went into the Navy. Spent about 4 years active duty initially. I've done about 4 more years recall since then, and the remainder in the reserves. I retired from the Navy last February, right before COVID hit. So got out at the right time, I think. I worked with the IRS for about 9.5 years as an estate tax attorney. I was the guy who called with an estate tax audit. And so I learned quite a bit of what I know about the estate tax world, really working with the attorneys and the CPAs who put together estate plans during those audits and reading their work and watching their work and talking with them. So I was fortunate there with the IRS to learn from the best. However, I did not have any clients and no one ever wanted to hear from me. So it's kind of a lonely job in some ways. I knew a couple of attorneys over here on the west side who slowly talked me across the water, and now I've been in private practice here in Paulsboro since 2012. That one bullet I just put in there to see if you're reading it. I've got a wife. When I graduated law school, I was not going to marry a lawyer, certainly not going to marry a Navy JAG. So of course, that's exactly what I did. We have 2 kids, 12 and 14. And I'm a partner with the Sherrard McGonigal Tisano and Lind firm here in Paulsboro. And that is, those are Seattle prices, by the way, just to be clear. All right. So we're going to talk about basic estate planning documents this morning, just so you have a lay of the land of what those things look like. First, the cornerstone is your will or revocable trust. Just a quick word on revocable trusts. They're extremely useful in some circumstances. We use them from time to time. But despite what you hear on financial planning shows and reading financial planning newsletters and magazines and articles, Washington is a very simple probate state. And so we tend to do a lot of our estate planning here in the office using good old-fashioned wills. If you've heard the horrors of probate, you've probably heard stories about California or New York or Florida. In those states, probate is a bear. It is expensive. The court wants to be involved in every step of the process. There are multiple players involved, all of whom want to be paid. And so it is definitely something to avoid in those states. Washington, we write what's called a non-intervention will. And basically that is a will that the court will bless, will issue letters testamentary, and then unless a problem comes up or you need help from the court or you need guidance from the court really doesn't want to hear from you until you're done. And so it's just a much more straightforward process. There's not a lot of difference in Washington between a will administration and a trust administration, to be honest. They're both fairly straightforward. If you've got real property in other states, that's a circumstance where you probably use a trust to avoid having to do a probate in each one of those states, because you have to do a probate if you've got real property located in another jurisdiction, or if you've got trust terms which lend themselves more towards estate planning terms which lend themselves more towards a trust, largely for confidentiality purposes. A will becomes a public record, a trust is not. We've used them in those cases. So the will or revocable trust is what takes effect, in large effect, after you die. What happens to your stuff? Where does it go? Who does it go to? And how does it go to them? The other documents come into play during your lifetime and are just as important to have in place. A durable power of attorney for financial decisions, a durable power of attorney for healthcare decisions. Both of those documents designate somebody who is your attorney in fact, who will make decisions for you if you can't. And so it's important to put people in those positions who you trust, who you know, and who want to do what's best for you and who know what you would want to have done, especially with the healthcare decisions area. The financial decisions power of attorney will typically draft as immediately effective. That way there's no need for there to be a doctor determination that you're no longer competent for the document to be in effect. The healthcare power of attorney by its very nature is what we call a springing power of attorney. You're making your own healthcare decisions until you can't, and then your power of attorney would step in to make those for you. The next document is a declaration to physicians or a living will. It's a document that states if you end up in a terminal condition or a permanent unconscious condition, also known as a coma, that you would therefore not want artificial means of support to be used to continue your life if it was determined that there was no chance you were going to return to any kind of a meaningful quality of life. So you're either bedridden, not competent to make your own decisions, and the docs have determined you're more or less terminal, it's just going to take a while to get there, or you are permanently unconscious and no reasonable likelihood of you ever regaining consciousness. A living will allow your healthcare power of attorney to remove dialysis and feeding tubes and trach tubes and whatever else is keeping you going to allow you to die a natural death. There are additional documents we can use depending on the complexity of your plan. Insurance trusts, retirement plan trusts, which we'll talk about here in a little bit. We can leave detailed funeral desires in a separate document. And then finally, something in Washington called a community property agreement. Not appropriate for couples who have estate tax issues, but a very powerful document for those who don't necessarily, to avoid really having to do anything probate-wise when one spouse passes. Don't use them very often, but for some couples, they do come into play. Insurance trusts are extremely helpful. They can take life insurance and move it out of your estate for estate tax purposes and allow for your beneficiaries to use the proceeds of that policy to pay estate taxes and to pay other expenses of administration. So as the federal estate tax begins to be more and more a part of more people's lives, I think we're going to see a return to these more complex plans. Planning for minors, if you've got children, grandchildren, nieces, nephews, anyone else, and you want to leave them property, not a problem. Generally, as we all know, minors can't hold substantial assets, so we use a trust. That trust can be in your will, it can be in your trust, it can be anywhere that your estate plan is contained. Our generic, more or less, minors trust is very broad. It allows the trustee broad discretion to spend the trust funds for the benefit of the minor. That includes basic support, healthcare, vacations, enrichment activities, education, tutors, really whatever is for the best interest of that minor is a legitimate expense of that trust. And then you pay it out to the minor at the ages that you determine. I don't recommend 18. That's probably not a good idea. So typically clients will start around 25, and then either it'll all come out at once or maybe over a couple of different ages. You select the trustees, don't have to be the guardians. So if it's not your child, if it's a grandchild, and you're not so sure about either the parents or the guardians, you can leave it to a different trustee, and that person will manage the money that you've left that minor. And then finally, we can put sweeteners in there. If the minor goes to a college or goes to junior college or goes to trade school and acquires a degree or becomes an apprentice in the trade, we can provide for a payout at that point, try to encourage education in a trade or profession. And we can use disincentives. If the minor has a history of substance problems, we, for example, put a requirement for urinalysis in there before any kind of distribution is made. So we can tailor these minor trusts according to your particular situation. So let's get into basic estate tax concepts. So the federal estate tax right now is a 40% rate on assets that you hold at death and lifetime gifts more than $15,000 per year per person. It's got an 11.7, it's a typo in the slide, I apologize, $11.7 million exemption this year. So it's a huge exemption. Almost none of us worry about the federal estate tax anymore. However, that is a topic of debate in Congress this year. Whether it stays at the 11.7, it comes down now, we'll find out as the summer drags on. And in any event, in the 2017 Tax Act, which took us from 5 million up to 10 million, basically adjusted for inflation, that that thing sunsets in 2025 with respect to the estate tax world. And so we'll come snapping back to probably around a $6 million federal exemption if nothing happens, which is still a big number. But as you can see, that federal credit could bounce around. The Biden administration has talked about reducing it down to as low as $3.5 million. So really no idea where that's going to go in the next few years. So it's important to be flexible and plan around it. Your taxable estate includes a lot of things you might not think about. It includes life insurance. If you own a life insurance policy outright and it's got a death benefit, that death benefit is part of your estate plan. Your real estate, certainly part of your taxable estate. 401ks and IRAs also are part of your taxable estate. So while the exemptions are large numbers, you can be a lot closer than you think, a lot faster than you think, especially holding real property here in Kitsap County and with potentially a 401k rollover. The Washington estate tax is a progressive rate from 10 to 20%, and it starts at $2,193,000. It seems like a weird number, right? It's been fixed at that number for about 4 years now due to how the 2017 federal tax act was written. So we're locked in at $2,193,000 until 2025, where if the 2017 tax act sunsets, our exemption is going to go springing up probably to about 2.4, 2.5 million. But right now, it's right below 2.2 million. There's no gift tax in Washington. So if you make a large gift over $15,000 a year, it doesn't matter. It's not part of your estate, it's gone. So you could have $100 gazillion, and if you gave away everything but $2 million the moment before you died, there would be no Washington estate tax. On the federal side, it would all get captured because that gift would be a part of your estate. Otherwise, the Washington taxable estate basically is the federal taxable estate. It's the same kind of tax return. It's just a lower rate, but unfortunately it starts at a lower amount. When you compare the exemption and the rates, Washington has the highest estate tax in the country. So definitely something to be planning to try and minimize to the extent possible. So simple estate tax planning. What do we want to do? Well, particularly with respect to a married couple, we want to use both credits. A husband and wife or two spouses have 2 credits for federal purposes and 2 credits for state purposes. And we don't want to be stuck with using just one. And we'll talk about how that can happen here in a second. When do you need to start thinking about estate taxes? And it's lower than you think. Federal, I would say 2 to 4 million. You need to be focused on the federal estate tax because we're definitely coming down in 2025 if nothing occurs. And we could be coming down even sooner than that, depending on what the Biden administration were to propose to Congress. So if you're over $2 million as a married couple or as an individual, we need to talk about the federal plan, at least to be mindful of it, make sure the plan would accommodate it. Now, certainly your age, your health, your investments all play a part. There's a big difference between a 98-year-old with a $2 million estate and a 48-year-old with a $2 million estate. Just the likelihood of that 48-year-old having a taxable estate is much higher, so we would definitely take that into account. Washington, in my opinion, once you go over $1 million of assets, you need to start thinking about the Washington estate tax, especially if you're invested in the market and if you own real property. Those 2 items are typically going to appreciate and going to appreciate faster than what you're going to spend. So at about $1 million with a married couple, start putting into some plans to make sure, again, that we use both credits. Now for Washington, we have no gift tax. So if we're fairly comfortable, we're not going to have a federal problem, we might have a state problem, we can consider some gifting during your lifetime to use that large federal credit and get the assets out of your estate for Washington purposes. So it's a viable option in Washington to use that. And again, remember, your taxable estate includes life insurance, it includes your 401k, it includes your IRA, certainly includes your house, includes really everything that you've got control over is going to be sucked into your taxable estate. So let's think about a typical estate plan for a married couple. Those of us in the estate planning world call it an I love you will. It's basically, when I die, everything goes to my spouse. If my spouse doesn't survive me, then to our kids in equal shares per stirpes. So what that means is that everything goes to each other outright, and then at the death of the second spouse, everything goes to the kids. If one of the kids were to predecease, that share goes down to the grandkids. Very traditional plan. It's a good estate plan. It's what most people in that circumstance more or less are going to want, with some tweaks here and there, perhaps, but it's very typical. The problem from the estate tax side is that we only get one credit as a result. So graphically, what happens here is the $3 million estate goes to the surviving spouse, who then owns everything. We've got a $3 million estate in our example. And so when that surviving spouse passes on, there's going to be a Washington estate tax of about $81,000 because we're only using the surviving spouse's credit. Everything that passes to a spouse is subject to the marital deduction. The marital deduction is unlimited. I used to use Bill and Melinda Gates as my example. I guess I'll have to find a new one. But if you've got an extremely wealthy couple who have an I love you will, upon the first death, there's no estate tax because the marital deduction takes care of everything. The problem is then the second spouse ends up owning everything, and we didn't use any of the first spouse's credit. So we can inadvertently result in a lot of estate tax. So again, the danger is that you're going to owe estate tax upon that second death. Now on the, I'll just take you through here. A couple of $1 million of assets. You've got to file the estate tax return within 9 months after the estate, after the person's passing, if you're taxable. On the federal side, we can file what's called the deceased spouse unused exemption amount portability, which is a DSUA election or a portability election. If you don't use the credit on the federal side and you file an estate tax return for that first death, the surviving spouse can port that credit with them, can carry it with them, and can use it when they die. It's a very unique thing to the federal government. Washington doesn't have that. Washington is a use it or lose it state. So in our example, on the federal side, might be okay because we probably would have carried that credit over with the first death. But on the Washington side, we only have the surviving spouse's credit. And so we end up with substantial estate tax due over $80,000. How do we fix it? It's a fairly straightforward plan that we would use. Instead, we would use something called a credit shelter trust to receive the assets of the first spouse to pass. So we'll use the same example, a $3 million estate, all community property, half and half. When the decedent dies, instead of everything going over to the surviving spouse, it goes down into a credit shelter trust for the benefit of the surviving spouse. Now, the terms of the credit shelter trust are pretty liberal. The surviving spouse is almost always the trustee of that trust. The surviving spouse gets all the income from that trust. So if it's invested in the stock market or in bonds or whatever, all the interest, all the dividends come over to the surviving spouse. If it's in rental property, the rents come over to the surviving spouse. The surviving spouse can also dip into the principal of that trust as they need for their health, education, maintenance, and support, which are IRS approved terms that basically means that the surviving spouse can continue the lifestyle they had when they were married, essentially. So if you typically took a vacation in July or took a cruise twice a year, the surviving spouse can continue to use the trust funds to take those cruises, take those vacations, purchase a car of a similar make as the couple always had when the first spouse passed on. So the goal here is to make this as transparent as possible for the surviving spouse. But since it doesn't pass directly to the surviving spouse, and since the surviving spouse can't just willy-nilly dip in there, that health, education, maintenance, and support does not mean that you can draw the trust out, fly to Vegas, and bet it all on red. So there are some limitations as to what you can do with the money. Just enough of a firewall there to keep that money out of the estate of the second spouse when they die. And it's not eligible for the marital deduction. So we use the credit of the first spouse. So in our example, the decedent passes on. He or she leaves $1.5 million to the credit shelter trust. It's not eligible for the marital deduction, so we have a $1.5 million taxable estate, but we've got a $2.193 million credit. So we just apply the credit to that, no tax. Now, when the surviving spouse passes, that trust is not part of their estate. So they've only got their $1.5 million. They've got their own $2,193,000 credit, no tax upon the second to pass as well. So with just a minimal amount of planning and just a minimal amount of firewall between the surviving spouse and the deceased spouse's assets, we avoid nearly $100,000 in estate tax in this example. So as you can see, what we're doing here is nothing more complex than just using both credits. This plan will allow us to pass basically $4.4 million onto kids or anyone else that you wanted to pass on to without having any estate tax assessed. Well, can anything be deducted from the estate tax returns? Or do we get any deductions at all? Absolutely. So the first one's important. Some people have come to me with questions thinking, I've got $1 million house, but there's a $750,000 mortgage on it. Are my kids going to have to pay estate tax on $1 million? The answer is no. The debts that you have either related to a specific property or just general debts are deducted from your estate. The expenses of estate administration are deducted from your estate. If you pass things, as I said, to a surviving spouse, the marital deduction is available. And so that's a nice safety valve. If the estate is large, then we can use the full credit and then have the remaining assets go directly to the surviving spouse and avoid estate tax upon the first passing. We can even use trusts, as I just talked about, and still get the marital deduction. There's a special type of trust called a qualified terminable interest property trust, where if you check a block on the tax return, you can still take the marital deduction even though that trust is not passing directly to the surviving spouse. The one I just described on the prior slide, I described a Q-tip. So we can use that one trust to either be a credit shelter trust or a marital trust, depending on what makes sense when that first spouse passes on. Using the same trust terms, it's just a matter of the elections that we make on the estate tax return. We can be very flexible with these. With the large federal credits, we've been taking advantage of the fact that if you die with an asset, your heirs get what's called a basis step up. So if you bought a house for $100,000 in Kitsap County back when it wasn't nearly as popular to live here as it is today, and now it's worth $1 million, and you leave that house to your kids, under current law, your kids receive a step up in basis, meaning if they turn around and sell the house, they would only pay capital gain on the amount over $1 million. That may be going away this summer. That's one of those things that's in debate in Congress. But what we've done in the past is we've kept that house in the estate of the second spouse for federal purposes and gotten it out of the estate of the second spouse for Washington purposes, just by electing what type of trust that is on the return. So as you can see, flexibility in a plan is important. A lot of these decisions are made, believe it or not, after the person has died. You can make tax elections at that time. As long as you got the plan in place, we can do what's called post-mortem planning to minimize taxes as well. The other big deduction is the charitable deduction. If you leave all or a portion of your estate to a qualified charity, basically anything you get an income tax deduction for, then that's a deduction from estate tax purposes. And that's another big safety valve, I'll call it, especially in single estate plans where the person doesn't want to pay estate taxes. They want to pass as much as they can on to their heirs, and charities are important to them. Then we might say the maximum amount that can pass free of Washington estate tax, $2,193,000, to my nieces and nephews, the remainder to whatever charity is important. So it can result in a zero estate tax that way. One lung trust I put up there just to talk about the fact that qualified terminable interest property trust, the Q-tip trust, I use that almost exclusively because it does so many different things. It combines credit shelter features with marital deductions. It allows for different Q-tip elections for Washington and federal purposes. And you can fund it really one of two ways, which even affords more portability. Either we do it this way: the maximum amount which can pass free of both federal and Washington tax over to the Smith Family Trust, which is a one lung trust. The remainder to my spouse outright. That's going to be mandatory funding. Under current law, $2,193,000 is going to be into the trust, the remainder over to the spouse, and then you can decide on how you want to treat the trust for Washington and federal purposes. There's surety to that. There's nothing the surviving spouse needs to do to make sure that happens. It's going to occur during the course of the estate administration. The other method I use is much more flexible, but it does require some action on the surviving spouse. basically it looks like an I love you will, everything to my surviving spouse, except if my surviving spouse disclaims any portion, then over to the Smith Family Trust. And that allows the surviving spouse to kind of pick and choose which and how much assets go over into the Smith Family Trust. They have to make that decision within 9 months after the date of death, and they can't monkey around with the assets a whole lot prior to making that disclaimer. So probably would have an account that you're just living out of and then considering what else you're going to disclaim. Very flexible, however, it does require action on the surviving spouse. So depending on the level of the estate and the comfort level of the client, I've used certainly both of those methods in the past. So I'm going to pause at the end of this slide to see if there are any questions. So the estate tax takeaways, just very simple planning right now can allow you to pass over $22 million, actually over $23 million now, to heirs without any federal estate tax. But stand by, that's likely going to be changing this summer. $4.4 million free of Washington estate tax. Now, as I put there, the federal credit is likely to decrease. On the first round that the Biden administration submitted to Congress on the American Families First Plan, I think it was where the tax legislation was, they didn't talk about messing with the federal credit limit at all. They were going to keep it at the 11.7 million. However, one big thing they're going to potentially eliminate is that basis step up in death. So as I explained, under current law, if you own something at death and you pass it on to an heir, regardless of what you paid for it, that heir takes it at its date of death value as their new basis. It's as if they bought it for that amount of money. So if they turn around and sell it, their gain is computed on that higher value. What's proposed is that that's still all well and good up to $1 million of gain. After $1 million of gain, the estate itself is going to start paying capital gains tax on the gain of the assets within the estate. So I'll use an example. Let's use the same thing we just talked about. Couple moved to Kitsap back in the 70s. They bought a $250,000 house back then, huge place. Now it's worth $4 million. And they pass it on to their kids. Well, there is $3,750,000 worth of gain trapped in that house. Sorry. Their kids would take the asset. The first $1 million of the gain would be tax-free, but the remaining $2.75 million of gain would be subject to the capital gains tax. And currently, the Biden administration is talking about making that the highest marginal rate, which would be 37%, potentially 39%. So keep your ear to the ground. If you've got highly appreciated stock, if you were an Amazon employee or a Microsoft employee or a Boeing employee forever, and you've got shares of that stock in your retirement account with a basis of about, $1, $2, $3, definitely need to be thinking about this. And for those who hold highly appreciated real property, we need to be thinking about this as well. Now, there's a possible fix for failing to plan on the federal side with that portability election. If you have the I love you will, and one of you passes on, we can make the portability election and you can still use that federal credit of the first spouse. There's no such fix for Washington purposes. You use it or you lose it, unfortunately. So review your overall assets and your overall plan with your kind of planning team and try to incorporate marital deduction planning and credit shelter planning to make sure that you are paying the minimum amount of tax possible to get the maximum amount out to your heirs. And I'll stop here and see if there are any estate tax questions before we dive into IRAs.
On the chat, there are no questions, but if somebody has a question, please unmute and ask away.
All right, doesn't seem like there are any, so we will go right into the IRA portion of this. So hopefully your IRA is set up where right now, and I'll go back to this slide, we are entering what I call an experiment phase. We, in the late 1970s, mid to late 1970s, there was more or less a decision made that we were going to shift as a country from the defined benefit plan, the old pension system. You worked for a company for 25 years and you got X amount every month of your salary once you retired. And that was the model that was in place really since World War II. And due to a lot of pushing and pulling by larger entities. There was legislation passed in the mid-70s and then solidified in the 80s, which really have shifted us over to a defined contribution retirement approach, where we don't really have pensions so much anymore, as we were able to save money during our working lives in either 401ks, 403bs, or IRAs, and that will be our retirement nest egg once we retire. Is it going to work? Don't think anybody knows. The first generation that kind of came through this is just starting to hit retirement age. So it's going to be rather interesting in the years to come to see if the great experiment is going to work or not. But the side effect from an estate planning side is that IRAs have become an increasingly significant part of people's estates. I'll even say back in 1999, when I joined the IRS, I would look at a $7, $8, $9 million estate, which back then was real money. I say that tongue in cheek, but it was a large estate. But the IRA in there would be 50,000, 75,000, 100,000 maybe, and it normally either went to the spouse or the kids. It wasn't part of the overall plan because the IRAs weren't that big. People weren't those 401ks had not grown yet. People weren't doing these rollovers. It was a $2,000 limit for IRAs for the longest time. And so they weren't really part of people's estate plan. They were just kind of a throwaway asset for people with large estates. Things have changed tremendously since then. In 2015, it's estimated there were $24.7 trillion in these retirement plans. It had doubled since 2000. So accelerating at a huge rate. And it was up a third since 2008. And I've got to go back to the Investment Company Institute and see, they update their numbers every now and then, but have not given anything more recent. I would say that's probably over 40 trillion now. I mean, the numbers have just been growing so fast. And IRAs accounted for 7.6 trillion of that back in 2015. That had doubled since 2007. So as you can see, these assets are just growing and growing and growing and growing as people have continued to contribute to 401ks and are rolling those into IRAs once they retire. Next bullet points are critical. IRAs do not pass under your will, regardless of who you name in your will. The IRA beneficiary designation that you have on hand with the custodian is what controls the IRA. So you could leave your entire estate to your kids. You could leave the IRA inadvertently to a prior spouse, for example, and that prior spouse is going to take the IRA. So it's important that you review your beneficiary designations on your IRAs and your 401ks and your qualified annuities on a routine basis, just to make sure that they reflect what you want. Particularly with IRAs, it's a very unforgiving statute. They are federal benefits. And because they're federal benefits, IRAs are controlled by the Internal Revenue Code. State law doesn't necessarily apply to them. So I'll give you an example. If you get a divorce and you've got your spouse listed on life insurance policies and joint bank accounts and all these other things, state law steps in and goes, you know what, unless you reaffirm this in the divorce decree, we're going to wipe all that out, because really nobody wants their former spouse on these accounts, right? So that will save you in most cases. But IRAs are strange creatures. They are federal creatures. So if you never remove that former spouse from the IRA, guess what? If you pass on, they're gonna probably take it. And we've had that in our office a couple of times, and it's not a good result. So please review your beneficiary designations. Also, the good thing about IRAs, like life insurance, they pass to your heirs free of creditors' claims. So if you have creditors in your estate, that IRA goes to your heirs, and the heirs can't, the creditors can't reach out and grab your IRA. Now, your heirs' creditors can, so can't save them entirely, but at least your creditors cannot. So I've just told you to designate beneficiaries. What's a permissible designated beneficiary? And by permissible, I mean they get to use the most advantageous method of withdrawing from the IRA possible. Basically, people, actual, honest-to-goodness human beings. So your spouse, child, neighbor, friend, worst enemy, just somebody who is a human being is who you want to designate as your IRA beneficiary in almost every case. Certain trusts specifically drafted to receive IRAs allow us to look through the trust to the people involved and still use the rules for those particular people when we try to determine how fast we have to draw down the IRA. We'll talk about those trusts as we move on. What are non-permissible designated beneficiaries? Meaning that they're stuck with either your distribution schedule or a 5-year payout. That would be number one, we see this a lot, estates. My IRA, and you filled out the custodial form, beneficiary, my estate. Please don't do that. That's bad, because while the IRA may be busted into shares and distributed out to your testamentary beneficiaries, they're going to take those inherited IRAs subject to the worst possible distribution based upon the pool of heirs. So in most cases, if you have not yet start drawing from your IRA, they've got a 5-year payout. If you were over 70.5 under the old rules or 72 under the new ones and you were drawing from your IRA, they're going to be using your payout scheme to determine how fast that is to come out. So almost never a good idea. Charities have to essentially draw down the IRA nearly immediately. However, as we'll talk about, charities can be fantastic beneficiaries for traditional IRAs. And then most trusts. The other thing I see a lot is my IRA is payable to the revocable living trust dated blah, 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 blah. Again, a circumstance where we can fix it in some cases, but unless the trust has been specifically designed to receive IRAs and you've deliberately made that beneficiary designation, just naming your revocable living trust, generally not a good idea. So we'll talk about the old rules, and those were in place before January of last year. So in addition to COVID, 2020 caused a huge change in the IRA world. The old rules were for traditional IRAs. If you left your IRA to your spouse, they could roll it over to a spousal IRA, which basically became their IRA. For purposes of that IRA, you never existed. The spouse is the new owner for RMD purposes. RMD meaning the required minimum distribution. Basically, you have to start drawing upon an IRA under the old rules at 70.5. You could start drawing on it at 59.5. And after that, once you're in the area where you have to take something out of an IRA, that's called your required minimum distribution. And so the spouse is the owner for RMD purposes. So once they hit the age trip point, they can do what they need to do with the IRA. The good news is that stayed in place, as we'll talk about in a second. If it passes to a non-spouse beneficiary under the old rules, that non-spouse beneficiary has to start drawing from the IRA the year after you die, but they get to use their life expectancy to draw it down, which means if you left it to a 30-year-old, they have about 40 years left, 45 years left under the mortality tables the IRS uses. So they would take 1/45th and 1/44th and 1/43rd, so they can very slowly draw the IRA down, leave as much in there as possible, let it grow tax-free inside the IRA. Their income tax hit as the money comes out of the IRA is not as big, and we called that a stretch IRA. That was a good thing. And we'll talk about in a second, that went away. IRAs not passing to a designated beneficiary, again, it's gone to an estate or non-qualified trust. You either, if the decedent had already hit 70.5 and was starting to draw on their IRA, then you're stuck with their RMD schedule. And estate planners having a dark sense of humor, we called that a ghost RMD. So it was the decedent's RMD schedule. Or if they weren't drawing on it, there was a 5-year payout required. Same rules for Roths, except that if you die prior to, if you don't designate a beneficiary, we always assume that you weren't drawing on it yet, so there's a 5-year payout. The only big difference between Roth IRAs and traditional IRAs for estate planning purposes is that as the money comes out of a Roth, it's not income. It's going to come out at the same pace, but it's just not going to be income to the beneficiary. What happened on January 1st, 2020? Well, something called the Secure Act was passed. It was setting every community up for retirement enhancement. And when Congress uses the word enhancement in an act, you can bet some people are losing big, and some people did, unfortunately. There were some good parts to it. It raised the RMD age up to 72. So if you weren't yet 70.5 when the act went into effect, you can now wait until age 72 before you have to start drawing on an IRA. So it was an extra 1.5 years that you can let it stay in the IRA if you don't need the money. The second good benefit was that you can now contribute to a traditional IRA after age 70.5 with earned income. So those are going to be wages and salaries largely. What the IRS determines is earned income. you can still put that into an IRA even after 70 and a half. So some people call this the Walmart greeter exception. So, it's probably not going to be used that widely, but it's in there. Spousal rules still in effect. So thank goodness, spousal rollover is still good. The surviving spouse can take the IRA, put it into their own IRA, and draw it upon their life, their ages, 59 and a half or 72. From an estate planning perspective, though, the key takeaway of that was the end of the stretch. So the new rule is, if you leave an IRA to a non-spouse beneficiary, instead of being able to use their measuring life to draw it down, they have to take everything out of the IRA within 10 years. So you can see if you left it to a 30 or 40-year-old child under the old rules, under the new rules, they've got to draw it down a lot faster. So it does two things. One, it accelerates the income tax bill because they're going to draw it out in 10 years as opposed to 30. Two, they don't get nearly as many years to allow the corpus, the body of that IRA, to continue to grow, either appreciating in value or dividends reinvested or whatever, tax-free. So it results in a larger income tax bill more soon than it would prior. There are exceptions to the 10-year rule, and we got a brand new acronym out of this, the eligible designated beneficiary, and these are important. Surviving spouses, but you're thinking I just told you that surviving spouses can roll it into their own IRA. That's true. There's one circumstance where a surviving spouse might want to use their life expectancy, however, to draw the IRA down as opposed to doing a spousal rollover. So eligible designated beneficiaries essentially can use the old rules. They can still use the life expectancy. Individuals less than 10 years younger than the IRA owner, I think the public policy there is if you leave it to your brother or sister and they're 3 years younger than you are, we'll let them use their life expectancy. It's not going to be that big of a delay as to what you would have drawn on it anyway. The next two are extremely important: chronically ill heirs and disabled heirs. That exception means that we can still use traditional IRAs and Roth IRAs to fund special needs trusts. So if we have someone who is disabled and is going to need Social Security, disability, or Medicaid, we can still leave an IRA to a trust for their benefit and use their measuring life to draw the IRA down into the trust. So, and that was kind of a last minute addition to the act, but a very important one. And then finally, minor children of the owner. So if you're a parent and you leave your IRA to your child who is under 18, they get to use their measuring life to draw upon the IRA until they hit 18. So very little is going to come out. But once they hit 18, they've got 10 years after that to draw it down. And then finally, if you are the beneficiary of one of these eligible designated beneficiaries and you receive the IRA, you don't get to use their measuring life. You're back into the 10-year drawdown. So I'll stop there and see if there are any questions so far.
None on the chat, but people are welcome to unmute.
Okay, we'll roll on then. Roth IRAs, always questions about Roth IRAs. Really, Roth IRAs, the only real difference between a Roth and a traditional for estate planning purposes is whether or not the beneficiary pays income tax on the amount that comes out of the Roth. Otherwise, Roths act exactly like traditional IRAs for estate planning purposes. The only exception is that if you fail to name a designated beneficiary for a Roth IRA, the beneficiaries that do end up with it are likely going to be subject to a 5-year payout. So they're even shorter than the 10-year payout that's afforded for a traditional. So Roths are great. Roth conversions are excellent. We'll talk about those here in a little bit. But for estate planning purposes, they act a lot like traditional IRAs. So I've told you don't use a trust for an IRA unless, and here's the unless. Generally not designated beneficiaries. If you leave it to a standard trust, as I said, we're either subject to a 5-year payout or the decedent's RMD schedule. Now, we could potentially use that to our advantage after secure. So let's say that you are the decedent and you were 74 years old. Well, your payout schedule is about 15, 16 years, believe it or not. So if you left it to an heir, they would take it subject to a 10-year payout that wasn't your spouse. Well, what if that heir intentionally disclaims, there's that word again, And as a result, the IRA goes back to your estate and then right back to your heir. Well, I think they would take subject to your 16-year payout as opposed to the 10-year payout. So there might be some planning opportunities here down the road. I haven't had it pop up yet, but my eyes are open. So if something like that presents itself, could very well take advantage of it. However, that said, specifically drafted trusts allow us to look through the trust to the beneficiary and then use the beneficiary's rules to determine how fast the IRA has to pay out into the trust. Now, they can be useful for a credit shelter amount. If you've got an example where a couple has over the taxable amount, but a huge percentage of it is in one spouse's IRA or both spouses' IRAs, for example. So they're extremely IRA heavy and they don't have enough other assets to really take advantage of the credits. We may use it in that circumstance, and it provides some spendthrift protection and special needs protection for beneficiaries. Very, very limited after the Secure Act. So the first one we will talk about are conduit trusts. Kind of a complex phrase, however, very simple concept. If the RMD comes out of the IRA into the trust in a conduit trust, the RMD goes right out to the beneficiaries. So that just flows through the trust to the beneficiaries. The terms of the trust make it so that the RMDs have to flow to the beneficiaries as they come out. It's useful for estate tax planning, primarily for a marital trust. The beneficiary can be the trustee, so you can still be the trustee of your own trust, and you decide how fast the RMDs come out, and then you would pay them over to yourself. Useful for marital conduit trust still. So again, we have that example where married couple, large estate, a lot of it is in IRAs. Maybe we wouldn't be able to put as much into a credit shelter trust as we would like to because their other assets maybe are fairly small. What we could do, instead of the IRA passing directly to the surviving spouse and becoming their own asset, we could pass a portion of that IRA into a marital conduit trust. And the spouse then, because there's the spousal exemption, remember, for the eligible designated beneficiary, they get to use their measuring life to pull it out. So if the spouse is 65 years old, they got about a 25-year payout. So they can use the old stretch rules to determine how fast the RMD has to come out of the IRA. And they get all of the RMDs that pass through. Now, when they die, we haven't made a marital deduction election for this. So a portion of that IRA then goes on to the ultimate beneficiaries, but is not in the estate of the second spouse. So it's a way to use the credit if we only have IRAs to work with. We'll need some clarification from the IRS because they specifically mentioned special needs trusts in the Secure Act, but did not mention marital conduit trusts. Believe all the practitioners, we all believe this will work still, but there'll probably be a PLR come out on it in the next few months. PLR being a private letter ruling, it's a way that you ask the IRS for permission, basically. Accumulation trusts are much different. They do exactly what the name sounds like. When an RMD comes out of the IRA, when a distribution comes out of the IRA, it's held in the trust. And it only goes to the beneficiaries if the trustee decides it should. And the biggest use for these is a supplemental needs trust. Sorry, I'm suffering from allergies. I'm about to lose my voice today. Again, chronically ill or disabled individuals are eligible designated beneficiaries and can use their life expectancy to draw down the IRA. So if an IRA goes into a special needs trust, then in most cases we can use the life expectancy of the beneficiary of that special needs trust to draw the IRA out, and then the trustee, who is not the beneficiary, can decide how much of that RMD should be distributed for the beneficiary's care. And that trust would still be an exempted asset for Social Security disability and for Medicaid. So unfortunately, the downside to this is trusts pay income tax at the highest marginal rate at a very low level of income. So keeping those distributions inside the trust result in a higher income tax bill than if it went out directly to the beneficiary. But those costs may be more than worth it if you're trying to put an IRA into a special needs trust for a beneficiary and keep them eligible for government programs. We can use it for spendthrift trust, we call it, if you've got a beneficiary who's just not good with their money. The downside is, again, in that case, if they weren't special needs, then all of the IRA would have to empty into the trust within 10 years because we'd use their rule, which is 10 years. And then unless you distribute it out to them, you'd be paying about a little bit over a third of it in income tax during the course of that time. So there's a cost, but if someone is really bad with money and all you've got to leave them is an IRA, it's definitely a possibility. IRAs and charities are a match made in heaven. So let's say that your estate is $2 million and you'd like to leave half your estate to your kids and half your estate to a charity. The traditional way to do it would have been leave the IRA half and half, and in your will say, my house goes half and half. And that way, house and all the other assets. So that way, your children and your charity each receive half. The downside, the downside to that being that when your children receive the traditional IRA, they're going to have to pay income tax on it. So it's not worth 100% to them. They're going to have to pay whatever their marginal rate is in income tax. The charity, they get their half. They don't pay income tax. They're a charity. So they get 100% of their half of the IRA. What I would tell a client then is, let's rethink this. Let's leave your IRA to the charity. That's $1 million going to the charity. They get every dollar of it. There's no income tax. And let's leave your other $1 million of assets to your kids. Again, it's not income, and so they get all of that as well. And so you've left your full $2 million to your kids and to the charity, just in a little bit different way. So traditional IRAs, if you've got a charitable part of your estate plan, especially after the Secure Act, my general advice is to strongly consider funding the charitable part of your plan exclusively with your IRAs and just leave your other assets to your other heirs. Whoops. So IRAs and durable powers of attorney, another very important area. In the old days, we used to rely upon what we call a general banking power within a durable power of attorney, which is that document I talked about, allows someone to manage your financial affairs. And if you said, I'd leave my attorney-in-fact power over all my financial accounts. IRA custodians used to say, good enough for us, you can do whatever you need to do with the IRA. That has become very problematic, and we've had to redraw powers of attorney with very specific IRA powers, powers to move from one custodian to another, powers to convert a traditional IRA to a Roth IRA, powers to designate beneficiaries on IRAs. You want all of those in your power of attorney to allow your attorney, in fact, the ability to manage that IRA. I'll tell you a story I had pop up a few years back. It was an estate on the east side, and an attorney over there gave me a call on an IRA issue. There was a couple that had done everything properly, everything proper, and their children were doing everything right as well, but they were hitting a stone wall. Basically, both of the spouses were no longer competent to manage their affairs, and so one of the children stepped in as the designated attorney. In fact, one of the spouses died. That IRA went to the other spouse. Everything's fine. That's exactly the way they'd set it up. The power of the attorney, in fact, the child, moved that IRA into a spousal IRA. No problems. Then they went to establish beneficiaries on that spousal IRA and named themselves and all the other kids equally, exactly what the couple had wanted all along. IRA custodian said, no, we're going to allow you to do the spousal rollover because that's what the beneficiary form said, but you don't have the power in that power of attorney to designate beneficiaries. You don't have any powers over IRAs. So in that case, we had to go into court to get a court order saying, yeah, in this case, the court does find that they've got the power to designate beneficiaries. But as you can see, even when everybody's trying to do the right thing, if the power of attorney is not drafted with IRAs in mind, you may be stymied from being able to manipulate them. And if the IRA is a large part of the estate, that's a pretty significant loss of power for your attorney, in fact. So I would encourage you to take a look at your older powers of attorney just to make sure that it's got the ability in there for your power of attorney to manage those accounts. So next steps. Actually, I'll stop here to see if there are any questions, and then we'll go on to next steps.
None on the chat bar at the moment.
Wow, okay. Well,
You're doing a
must-
fantastic
I was
job.
about to
Very
say,
thorough.
wow, okay, excellent, excellent. So if there are any questions, down the road, feel free to reach out to me. Big way you can do that is through scheduling an initial consultation. My hourly rate is typically $300 per hour to work with estate planning clients. However, is a special offer to seminar attendees. I'll sit down with you for a 2-hour consult for $100, and we'll take a look at your current plan, take a look at your IRAs, your life insurance policies, your annuities, and get a feel for what your current plan is. And in some cases, everything's properly drafted, everything's tightened up, and I will basically tell you that what you want to do, that's what these documents do, and you gain the peace of mind of another review of those. If, however, your IRA beneficiary designations maybe aren't in place, or you've only got spouses listed and no alternate beneficiaries, or your estate planning documents are a bit older, potentially you've got guardians still in place for your kids who are now 45 years old, be time to update those. My general rule of thumb is if you pick up your will and the pages stick together because of the carbon paper that was used to make the copies, probably a good time to take a look at that estate plan. Or if it smells like old mimeograph fluid, that might be a good time as well. And I've seen all types of wills that way. We'll take a look at that and your powers of attorney as well. Those almost always need to be updated. There was a significant update to the Washington Power of Attorney Act in 2017. So we would update those and name new fiduciaries if necessary. You might have named people back in the early 1990s, which made sense, and they don't make sense anymore. And then we'll discuss your current plan and any changes needed and move forward if you should choose to do so. So I'm going to leave you in the very capable hands of Mary, who's got the super whammadine hot link to our office and can get you on my calendar. Would love to sit down with you, if for no other reason than just discuss your plan, explain the plan. And maybe it's been a while since you've really looked at the documents, and a lot of times it's helpful if I just tell you what's in there. Here's what your plan does currently. Your prior attorney may not have explained it, or if he or she did, you may have forgotten it by now. So often helpful just to know what's in your current plan, and we'll move forward as necessary. So I'll ask one more time if there are any questions, and if not,